Please raise your right hand for me. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Put your hand down. Mr. Wheelock, if you have any questions, go ahead and ask me. If you need more time to talk to Mr. Gilbert, go ahead and let me know, okay?
Yes, sir.
All right, I have to advise you the maximum penalty that you could face for these charges. 7123. Count one, delivery of methamphetamine with, it's a 20-year felony or $25,000 fine, but with the habitual fourth notice, it'd be a maximum life in prison. Count two, delivery methamphetamine, 20-year felony, $25,000 fine, but with the habitual fourth, it'd be maximum life prison. Count three, delivery of more than 50 grams of hydrocodone, 20 years and or $25,000 fine with consecutive sentence discretionary. The habitual fourth makes that a statutory or maximum life. Count four, computer crime, 20-year felony, discretionary consecutive sentencing. Habitual fourth would be statutory life. Count five, computer crime, 20-year felony, discretionary consecutive, plus with the habitual life max. Count six, computer crime, 20 years, 20-year felony, discretionary consecutive, habitual fourth life. So by my count, that would be the deliveries concurrent, the delivery meth concurrent, delivery of hydrocodone, discretionary consecutive, and then three computer crimes. That would be, it sounds nonsense to even say it, but the maximum penalty that you could face in for these charges would be 5 lives in prison. Do you understand the maximum penalty?
Yes, sir.
In file 7124, count one is using a computer to commit a crime. It's a 4-year felony and or $5,000 discretionary consecutive. With the maximum, with the habitual fourth, it's a discretionary, I'm sorry, that's a 4-year felony. So there's the habitual four would make it a 15-year max. And count two, the attempt possession is a high court misdemeanor, 2 years and or $1,000 fine, but with the habitual fourth would be 15 years. With the discretionary consecutive, the maximum penalty you have in 7124 is 30 years. So between the two files, 5 lives plus 30 years. You understand the maximum penalty?
Yes.
Were you on probation or parole?
No.
Were you on bond for any other case at the time of these incidents?
No, sir.
Did you read and understand the rights listed on the advice of rights form?
I did.
Can you sign that form?
Yes.
Do you have any questions for me or Mr. Gilbert about any of those rights?
No, sir.
Do you understand if you plead guilty, you give up those rights and won't have a trial?
Yes, sir.
And is that what you wish to do today?
Yes, sir.
By pleading guilty, you give up any claim that your plea was caused by any threats or by any promises outside the plea agreement. Do you understand that?
Yes, sir.
Also, you give up the right to appeal, and if you want to appeal, you have to seek permission by filing an application. But the types of issues you could raise on an appeal are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, sir.
The plea agreement provides in exchange for your plea to those charges and restitution of $340. There's a sentence agreement for recovery court. Do you understand the terms of that plea agreement?
I do, sir.
Okay, now, I'm not bound to follow that sentencing. If I think it's not appropriate, I don't have to continue in that program. But if I didn't, you'd be allowed to withdraw your plea. Do you understand that?
Yes, sir.
Now that's unless, let's say between now and sentencing, you just abscond, or you start selling drugs or engage in some serious misconduct like that.
Yes, sir.
Then by your own misconduct, you'd lose the right to withdraw the plea, even if I didn't give you recovery court. Do you understand that?
Yes, sir.
All right. Now, if you are, only you know what's in your head and heart, but if you are 100% committed to changing everything, then this could be a good plan for you.
Yes, sir.
However, as I just read to you, you're eating all these charges. If you're going to play games in recovery court and not make it through, the sentence you get is going to be much more than what Mr. Gilbert could work out for you now. Do you understand that?
Yes, sir.
So are you sure you want to go into a recovery court program?
Yes, sir.
Only about half the people make it out of it.
Understood.
That's not because we build the program to fail. We do everything to help them succeed. But some folks don't want to pursue that path. whatever reason.
I need this.
So I only want you to do this if your eyes open and you intend to do it.
Do, sir.
All right. Well, knowing all this, how do you wish to plead to the charge in 7123, count 1, delivery methamphetamine, count 2, delivery methamphetamine,
Guilty.
count 3, delivery hydrocodone,
Guilty.
count 4, 5, and 6, or count 4, computer crime,
Guilty. Sir.
count 5, computer crime,
Guilty.
count 6, computer crime,
Guilty.
and habitual fourth notice.
Guilty.
And in files 7014, how do you wish to plead to count 1, computer crime?
Guilty.
Count 2, attempted possession of cocaine, or I'm sorry, of hydrocodone,
Guilty.
and habitual fourth.
Guilty.
So, Mr. Wheelock, back last spring, April of 2025, did you deliver the controlled substance methamphetamine to another person?
I did.
Did that happen on 2 different occasions?
Yes.
Did both of those deliveries occur in Sheboygan County?
I did.
Did you know what substance you were delivering?
Yes.
You're not a pharmacist or a doctor. You don't have any authority to deliver that. Is that right?
No, that's right.
And did you also, in April of 2025 in Sheboygan, deliver less than 50 grams of a mixture containing hydrocodone?
Yes.
And did you know that that was what you were delivering?
Yes.
Did you have any lawful authority to deliver?
No, sir.
With all 3 of those deliveries, did you use an electronic device connected to the internet that would constitute a computer system to facilitate that delivery?
Yes, sir.
And then later in the fall, October of 2025, did you use a computer connected to the internet again to facilitate, was this you facilitating the purchase?
Yes, sir.
Okay. And you used a computer to facilitate that crime?
Yes.
Okay. And then you did attempt to complete that purchase and possession of hydrocodone?
Yes.
Something happened that prevented that?
Yes.
Was this what's commonly known as a reverse buy from
Yes.
same?
Yes.
Okay. And at the time of all these incidents, did you have prior felonies for maintaining a drug house in 2010,
Yes.
possession of narcotic in 2013,
Yes.
larceny building 2013?
Yes.
Looks like 3 counts of delivery in 2020,
Yes, sir.
uttering and publishing 2 counts in 2019.
Yes, sir.
Mr. Gilbert, you're satisfied with the factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes,
Mr. Gilbert, you aware of any other promises, threats, or inducements?
I am not.
Ms. Goodrich?
I am.
Mr. Gilbert, your judgment, I complied with 6.302.
Believe the court has. Thank you.
Ms. Goodrich?
Yes,
Mr. Wheelock, I find that your pleas are knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of those offenses, so I hereby accept you to be guilty. I think I might want to set this sentencing out to the end of April, just to let them get started in recovery court and see where we're at. Any objection to that?
Not at all.
Okay, Ms. Goodrich, second.
that is.
Okay, we'll schedule this for sentencing on April 28th at 2:20 in the afternoon.
Your Honor, I have a question.
Yeah,
Does recovery court meet on Wednesday mornings?
it does.
Will I be here tomorrow morning then?
Yes,
Okay.
yes. Any objection to amending bond conditions to begin them right now,
No objection.
Mr. Gilbert?
No, no.
Okay, so Mr. Wheelock, we're gonna amend your bond to have it be recovery court conditions. So we'll get you started right now. And what that means is if you're sentenced into it, you get credit in the program for the time starting tomorrow.
Okay.
So I want you to stop by, see Nicole if she's here, see probation, let them know that you entered a plea. Well, you'll see somebody tomorrow too. And tomorrow morning, tomorrow morning, I think we might not have any women participants on for phase 1. So I think we normally would have you come at 9:30, but why don't you come tomorrow morning at 9 a.m.?
Come tomorrow and
Yeah.
I'll be here.
Okay. Do you have any questions for him, Mr. Wheeler?
No, one, do I call the bond hotline for testing
Yeah, I guess call it tomorrow morning unless Nicole's got you set up with something different. I'm not exactly sure what the logistics are of how that shifts with between that and recovery court. So unless, if you talk to Nicole today and she gets you set up with the recovery court with a different number or something, then do that.
Okay,
But otherwise, call the bond line.
sure.
All right, see you tomorrow morning, 9 a.m.
Thank you, sir.
All right. Over to Procedural Eisler,
Oh, there he is.
25-7105 FH up for docket call. What's our status?
Yes, Your Honor. I've requested a transcript from the preliminary exam. I did follow up on, I guess there was some confusion. We ended up sending 2 in. However, I've been informed that the transcript should be done fairly quickly. So I'm just asking for this to be moved out. My intention is to file a motion. in that
You do
case.
intend to file a motion?
I do.
Um,
That's the reason for the transcript.
okay. Do you think you'd have the transcript in time to get a motion noticed up for the March 17 day?
What's the next date?
The next one is at the end of April, which we could do if there's no objection.
No objection.
Okay.
Thank you
just
very
do
much.
that. Let's put this on April 28 at 2:10 in the afternoon. I'll indicate that that'll be a motion cutoff. We won't have it be a plea cutoff. I mean, it may depend on the motion. Continue. All right, anything further from the defense?
No, Your Honor. Thank you very much.
Anything further from the people?
No, Your Honor, thank you.
We will see you then, Mr. Eisen.
Okay, sounds good.
All right, we're going to call next People v. Kyle Kiska, file 25-7065. Also, you want to state your appearances, please?
Mr. Goodrich, Wayne County
What
Prosecutor.
am I doing? One sneaks up on me, the other one I think.
We got Mr. Gilbert for the defense. We're
Sorry.
here for sentencing on OWI 3rd, 0 to 6. Charlevoix Recovery Court recommendation. Mr. Gilbert, any additions, corrections, or scoring challenges?
No, Kyle and I went through the pre-sentence report. I looked at the scoring. I have no challenges or corrections.
Any from the people?
There.
And this is a transfer out to Charlevoix, right?
That is correct.
And I have the memo of understanding. Looks like it's all been signed. Okay, anything you want to say, Mr. Kiska?
Yes, Your Honor. I'm talking with Kyle. He's already been involved with the recovery court over there. I believe he's done it for a couple of weeks. And he really is telling me that he wants to embrace this. And as he knows that there's quite a bit hanging over his head. So I wish him the best of luck and ask the court to follow the recommendation.
Mr. Kiska, anything you want to tell me today or no?
I just appreciate the opportunity to do it. I'll make the best of it.
Okay. Ms. Goodrich, any recommendations from the people?
I continue the recommendation of Charlevoix Recovery Court.
All right, well, Mr. Kiska, this is, looks like a true third, but it was a very high BAC. And I think you got yourself even kind of worried about what was going on, that you ended up calling the police for some assistance. I think a treatment court is appropriate for you here. You've been accepted into the Charlevoix court. We've signed the documentation to transfer you over there. So this is the last time I'll see you on this case. If you violate, then the judge in Charlevoix County will impose a sentence. We're going to transfer the entire case over there. Okay. I'm going to place you on probation as recommended for 3 years, subject to the terms and conditions listed on pages 2 and 3 in the pre-sentence report. Chief among them are completing the Charlevoix County Recovery Court program. There's also fines and costs as ordered by Charlevoix. I'll follow their recommendations. $130 crime victims assessment, monthly supervision fee, $300 in court costs, $500 fine, $250 OUIL reimbursement, $60 DNA fee, $168 in state costs, $600 drug court fee, and $200 fine. Looks like it's 100 for the cost of prosecution, and 100 to the arrest or agency fee. I'm not exactly sure how that sorts out, but that must be a Charlevoix thing. I don't tend to do that. But we'll impose those, and that's within the advisory guidelines. It's consistent with the plea agreement. Mr. Kiska, if you want to appeal, you'd have to ask for a lawyer within 6 months. We're going to hand you a piece of paper explaining that process to you. Ask you to initial one copy for us. The other one is for you to fill out if you want to take an appeal. Do you have any questions for me, sir?
No, sir.
Okay, and that's, I guess, the probation order should probably only include the felony, I imagine. On the misdemeanor counts, it'll just be the fines and costs. All right, good luck to you, Mr. Kiska.
Your Honor, currently, he has a sober link. Is he required to still have that, or is that something he needs to address with Charlevoix?
You'd have to ask Charlevoix. I guess what I'll say is any bond orders that you have end today. So if you only use the sober link because of a bond condition,
yeah,
the bond condition ends right now.
Okay, thank you.
But whatever conditions of probation recovery court has on you, you follow those. Okay. So I would continue using it until you talk with your recovery court case manager.
Okay.
All right, we've gotten a little bit behind schedule here, but are you ready with Mr. Noah Hansen?
Mr. Hansen's incarcerated. Your
Oh,
Honor.
is it?
Yeah.
Okay,
My last two cases are both incarcerated.
Weston, okay, I see.
Mr. West.
Yeah, Mr. West. Yeah. All right, up next, we have People v. Walter West, file 25-7045FH for sentencing. Counsel, you want to state your appearances, please?
Anthony Juliet, people.
And James Gilbert here on behalf of Mr. West.
All right, we're here for sentencing on an attempted embezzlement over $1,000, advisory guidelines 0 to 17. Mr. Gilbert, have you had a chance to review the report and recommendations?
Yes, Your Honor, we went through it last week and again this week.
All right, so I have talked with counsel. We did continue this to address some jail credit issues that we'll hear argument about. But in looking at that, it looks like Mr. West's failure to appear for our sentence date, he had either that day or the day before turned himself into Kent County Jail on another matter. Is that correct, Mr. Juliet?
Yes.
So do I understand the people to agree with the defense that OB 19 should now be scored at 0 points?
Correct.
Okay. And Mr. Gilbert, that changes it to 10 points or 10 total OB points, level 2 and 0 to 11. Is that correct?
That is correct.
Do you have any other scoring challenges?
No other scoring challenges, no.
Okay. And I guess I would indicate also, Agent Young, I know there's been some question about this. What I'm treating now is an attempt 5-year changes the grid, but doesn't change the statutory max. So I'm using a statutory max of 60 months.
Very good, Your Honor.
All right. Any scoring challenges from the people?
No.
I guess, do we want to address the legal argument on the jail credit first, since that's a PSI issue? Mr. Gilbert, your position about jail credit?
Well, Your Honor, the prosecution brought up the jail credit issue last week, and we've had a lot of conversation about it. My position is that once this court revoked bond, when my client didn't appear, granted he was at Kent County, when you revoke bond and issued a bench warrant, he was no longer on bond, and from that point of his incarceration should get credit towards the time served. So I'm stating that the full amount that is in the PSI should be credited. I think we have to adjust it for the 1 week, but that so it'll be 98 days. In that 20 days that was between Kent County, him going into Kent County, and I believe him being arraigned on his matters here should be counted. Thank you.
All right, thank you. Mr. Juliet, I did receive and review and appreciate very much your detailed sentencing memo about your position with the jail credit. Any argument you want to make on that point?
I'll just supplement it, Your Honor. As of last week, the recommendation was for 91 days of credit. That would change to 98 days because of the adjournment this week. It's my position that as of last week, he should only earn 63 days of credit. That would be 70 days of credit this week. My argument, I guess, is that the 3 days on the initial arrest should be counted as credit in this case. And the remaining 28 days that he sat in the Sheboygan County Jail when he was brought here from Oakland County to today's date should be counted as well. We have 28 days unaccounted for from when he was in Kent County and or Oakland County. I'm not sure to what extent he was serving a sentence in either of those counties. But it's my position under MCL 769-11B and pre-scorn, interpreting that he is not entitled to credit for those sentence or those cases rather out of Kent County and or Oakland County because it's not arising out of conviction here. And I'll just quote from an unpublished case. It is People v. Murray, January 15th, 2026, docket number 375860. The Supreme Court found that the plain language of the statute, that being MCL 769-11B, affords a criminal defendant a right to credit for any pre-sentence time served for the offense of which he is convicted and not upon any other conviction. So when he's convicted here, he turns himself into Kent County and begins, he's in their jail there. He's then transferred to Oakland there. He is in their jail because of their cases, not because of our case. I understand there was a bench warrant. I think that's immaterial, especially when the Supreme Court has interpreted the statute that he's entitled to credit for the offense of which he is convicted and not upon any other conviction. So I believe those convictions down there do not entitle him to credit here. So it's my position that he's only entitled to 70 days credit.
Thank you. Well, jail credit is a thornier issue than one might think. The statute simply says that if you're convicted of a crime and you've served any time in jail prior to sentencing because of being denied or unable to furnish bond for the offense of which he's convicted, then you give credit against the sentence for the time served in jail. Sounds simple enough. But what complicates it is when people have more than one case pending and they're in jail trying to figure out, well, why are they in jail? And the cases from the Court of Appeals and the Supreme Court over the years only give us a few clear rules. One, if there's a parole detainer, then you don't get credit because you're in jail on the parole hold no matter what. Second, if you're serving a sentence somewhere, then you don't get credit for the time you're serving that sentence, no matter what, because you're serving that sentence. Here, that might have happened in this, but we don't have enough information to sort that out. So I don't think I can apply the Givens case to deny credit for serving a sentence. Another one is if you post bond in your case here and you end up in jail on another case somewhere and your bond never gets canceled here. Well, then the case law says you don't get credit because you were serving on another case, not on this case. But there is some very strange reasoning in these cases and some of the unpublished cases that the prosecutor's relying on, that where there's two cases, or here three, Kent, Oakland, and Sheboygan. The prosecutor's saying that when he's in Kent County, even though he's got a no bond warrant with us and there's a hold on him, that even if we didn't have that hold, he'd be serving in Kent County, so therefore he shouldn't get the credit. I do think that reasoning, read broadly enough, goes fairly circular, so that if you have two cases you're in jail on, in case one, the judge might say you don't get any credit because you, even if you were on bond, you'd be held on case two, so therefore you don't get any credit in case one. But it seems to me that the judge in case two could say the same darn thing and say, well, because even if we granted you bond, you'd have been held on case one, so you don't get any credit. So somebody who's in jail on two different cases would get zero credit. And it seems to me that can't be consistent with the statute, which the cases say is to be applied liberally to grant credit. So here, when he was in Kent County Jail, It seems on review of the PSI, he was in Kent County Jail for 3 reasons. 1, Kent County had their hooks into him for something. 2, Oakland County had a hold on him because that's where he went next. And 3, I had signed a warrant for his arrest with no bond. So I would not give credit if he was in Kent County instead of on our warrant. But I think he was in jail in Kent County because of Kent County matters, Oakland County matters, and our warrant. So under those circumstances, I would grant him that credit. The 91 days in the PSI plus the 7 days that we've adjourned it. So I'll give 98 days jail credit to the incarceration imposed today. All right, so Mr.
Thank you.
Gilbert, anything you want to say in support of Mr. West?
Yes, and first off, thank you for that ruling, Your Honor. I know Mr. West is acknowledging and trying to take care of everything that he's got floating out there, including that's the reason he turned himself into Kent County. He wants to put this behind him. It's my understanding that he's been doing well in the jail. We know that there's going to be some additional incarceration. We'd ask that to be least amount possible. And also, if there's an additional incarceration, if any type of jail program like trustee, or I believe there's another work program that the jail is beginning to review, that my client be eligible for that. And again, I think Mr. West stands before you very remorseful and trying to get his life back in shape. Thank you.
Thank you, Mr. West. You don't have to tell me anything today, but you're welcome to. Is there anything you want to tell me or not?
Just sick of letting people down, my family, my wife, my kids. Just want to make this right and be a good dad and a good husband and try to add to my community instead of disrupt things.
How do you think that's going to happen?
I stick into my head and doing my stuff and not making idiotic decisions. Sorry, Your Honor, I'm just nervous. I
That's
get
fine.
a hard time talking.
I mean, it seems to me you got a significant history of some larcenies. So your problem seems to be that you're not satisfied with what you got going on and you take from other folks. So that seems to me an easy change you can make to stop letting your family down is to stop stealing.
Yes, sir.
That's 100% in your control, right?
Yes, sir.
All right. Well, I wish you luck with that. I really do. Mr. Juliet, any recommendations from the people?
Yes, we did submit a restitution request for $7,430. I don't know if that's being stipulated to, or if we have to have a hearing on that.
Any objection to the restitution amount?
We have no objection to that restitution amount. That's correct, right?
Okay.
Otherwise, Your Honor, I would ask for a sentence of 11 months. I mean, he's what I would categorize as a serial thief. I mean, that's nearly all of his convictions across the state of Michigan. He's been on probation for almost all of them, and it stopped working. So I'd ask for an 11-month sentence.
Thank you. Well, Mr. West, there's some financial assessments, $7,430 in restitution, $130 crime victims assessment, $350 in court costs, $68 in state costs. Also, I'll dismiss the pending contempt for failing to appear because that wasn't contemptuous. He was in jail in Kent County. And the guidelines are now at 0 to 11 months. I don't know, Mr. West, I mean, I hope that you mean what you said today, and I hope that you're able to do that. But for today's purposes, I mean, I have to agree with the prosecutor that this is not an isolated incident. You've got a history of stealing, and probation hasn't encouraged you to change. So now the tool in the toolbox is that you get jail. And if you keep stealing and committing felony stealing, then the next step is going to be prison. And you're not that far away from it. So I'm going to order that Mr. West serve 11 months in the Sheboygan County Jail. I'll give him credit for 98 days previously served. I will indicate that I have no objection to his participating in the jail trustee program if the jail determines him eligible.
Thank you.
Mr. West, if you want to appeal, you have to file an application. If you want a lawyer, you'd have to ask me within 6 months. We're going to hand you a piece of paper explaining that process. Ask you to initial one copy for us. The other one's for you to fill out if you want to take an appeal. Good luck to you, sir.
Your Honor, was that also including his work?
No. If we're doing like some work crew program out of the jail, I'm not going to approve that for felony matters. We have people be Noah Hansen, file 25-7108. For a docket call and a status conference on a pending bond violation. Mr. Gilbert, what's our status here?
Your Honor, in regards to the underlying case, this matter has not been resolved. So I don't know if the court, how the court wants to handle that, but.
We want to continue it to March 10th at 3:20.
Okay, thank you very much, Your Honor.
All right, anything further from the defense?
Not in regards to the docket call, Your Honor.
Go ahead on the contempt.
My client wishes to admit that he was around marijuana and, yeah, he failed to pass the test and had violated his bond. So he wishes to admit that, and I would ask the court to give him time served and ask the court to possibly reinstate his bond. I mean, you have a young man that has served 27 days in jail, and I think he's learned his lesson, you know, and talking with him. He's 19 years old, and talking with him while he's in the jail. It was I think it's quite the eye-opening experience for this young man, and I would ask the court to consider letting him out. Thank you.
Okay, Mr. Hansen, as best you can, raise your right hand for me. Swear to tell the truth, the whole truth, and nothing but the truth, so okay?
Yep.
Okay, put your hand down. Has anybody promised you anything in exchange for your plea of contempt?
No, sir.
Has anybody threatened you?
No, sir.
How do you wish to plead to being in contempt of court? Guilty or not guilty? And it's just on the contempt, not the underlying case. Okay. So you know, as a condition of your bond, you were required to not use or possess controlled substances and were required to pass urine sample drug testing?
Yes, sir.
And did you test positive for marijuana?
Yes, sir.
Is that because you were around marijuana? And you knew that that violated your bond? Mr. Gilbert, you satisfied?
I am. Thank you.
Yes.
All right. Mr. Hansen, you don't have to tell me anything about the contempt sentencing, but you're allowed to. Is there anything you want to tell me about that or no? You can just let your lawyer said some things for you about that. But you can add to that if you wish, but you don't have to. I don't hold it against you if you don't. Do you want to say anything about that?
It was an eye opener for sure, being in here, and I just want to do better. Do better for my family and my siblings, and seeing them hurt like this. Still want to do it to them anymore.
Ms. Goodrich, any recommendations on the contempt sentence?
Your Honor, the concern here is that he's facing serious charges and came before the court on a marijuana violation while smelling strongly in court of marijuana, and the seriousness that he's taking the privileges that were awarded to him on bond. Yes, I would ask for credit for time served. It looks like he's been in there 27 days, but I would ask that his bond remains revoked.
Okay, and the contempt will enter a sentence of contempt with 27 days jail credit for 27 days previously served. Do you know what the bond was set up for?
Okay, yeah, I thought it was a PR.
It was a
bond,
PR bond.
but I thought it was PR.
Well, Mr. Hansen, it seems to me the last, time you were in court that, you just weren't taking the process or the charges that you're facing. And I don't know if you're guilty of those charges or not. You have the right to a jury trial, but the process is a serious one.
Yeah.
And we've got lots of detailed process so that we don't just throw people in the jail without due process and without hearing and without a right to a jury trial. But this is a serious process. And I know you're only, what, 19?
Yes, sir.
Okay, but it seemed to me that you thought it was kind of a joke and I really wanted to get your attention. And so I don't know whether we've gotten it yet. Mr. Gilbert says that we have, and your demeanor does seem to be different. I'm going to reinstate bond, $5,000 personal bond, the same conditions. But I want you to know whether you take this seriously or not. I take it very seriously. And so if you don't take it seriously, I will lock you up. Okay?
Thank you very
All right,
much.
we'll see you March 10th at 3:20 in the afternoon. All right, Mr. Gilbert, is that all your matters?
I believe that
Could you
concludes
please
my-
approach with Ms. Goodrich?